Hello and welcome back to the GDPR and Data Protection Diaries. In this video we are going to be talking about Brexit. More specifically what Brexit means for data transfers for organisations under the GDPR, what you need to do to be prepared for that, and how easy it is for you to get that in place. We are going to be concentrating on standard contractual clauses. So we are going to be looking at data transfers in the event of a no-deal Brexit, and realistically in the event of a Brexit, whatever happens. So as always, if you find this video useful, please do give us a like, give us a comment, give us a share. Obviously, if you're watching this on YouTube and you've gone through to the channel, make sure that you subscribe to the GDPR and Data Protection Diaries, and you can find more content like this. And of course, as always, let us know if you have any questions. So what is the concern? So the concern today is that we are going to exit the European Union on the 31st of October, and it's looking likely that we probably won't have a deal. And what does that mean for your organisation? Well, on the 31st of October, if we exit the EU without a deal, and even if we exit with a deal, to be honest, it's looking very, very likely that we won't have what is known as an adequacy decision, which means that the UK will become a third country. So under the terms of the regulation, under the terms of the GDPR, we will no longer be bound directly by European law. And that means that the protections that are afforded to European countries and people within the European Union won't necessarily be attributed to individuals within the UK anymore. So we have to find a different way of giving individuals those rights and making sure their freedoms are being accounted for. And the best way to do that, and the simplest way to do that, is actually to use something called standard contractual clauses. So if you've been reading anything on the ICO website, or you've seen any webinars, you will have seen lots of people talking about standard contractual clauses. This is a really simple way for an organisation to demonstrate that the people or the company that they're sharing their information with, i.e. your organisation in the UK, takes data protection from an EU perspective seriously, and it's a good way of making sure that you can control that and transferring data without having to have any other permissions in place. So standard contractual clauses are EU agreed. They're also accepted as adequate by the UK, which means that they can be used to move information from outside of the EEA, from inside the EEA to a country outside of the EEA. In this instance, transferring data from Europe into the UK in the event of a no-deal Brexit. Standard contractual clauses essentially apply when the country that you're transferring information to doesn't have what is known as an adequacy decision. So an adequacy decision is when the European Commission has looked at the country, looked at their data privacy laws and said, you know what, we are comfortable with our individuals' data, our citizens' data being transferred to that country based on the laws that they have in place. Adequacy decisions have been applied to organisations or countries, such as Japan, Sweden, Norway, Liechtenstein and a number of other places in addition to the EU. At this point, the UK won't have that decision, so standard contractual clauses are a way of documenting that in an agreement, making sure that your organisation in the UK gives the information from the EU the same level of control and the same level of respect to the rights and freedoms as it would do if it was based in the EU. So who should be signing up to standard contractual clauses? Well, if your organisation is providing products or services to companies from within the EU, or you are managing data on behalf of companies within the EU, then you are likely to be asked to sign up to standard contractual clauses by those parties. A processor, so if you are handling information for a organisation within the EU and you are processing it in the UK, then you are likely to need to sign up to standard contractual clauses. There's some really, really useful guidance on this from the ICO website for small and medium enterprises. For larger organisations, you're going to need to get some legal advice, and you're going to need to get them to look at the clauses and make sure they're inserted effectively into your contracts. The important thing is that the standard contractual clauses are predetermined. They do not change. You do not need to amend them. They are agreed. They are literally a drop and insert item. And as it stands, they are still permitted and they are still seen as acceptable. So you don't need to change them. You just need to insert them into the contracts in those instances that you are transferring data from the EU into the UK in the event of a no-deal Brexit. So what are the benefits? Well, standard contractual clauses will allow your organisation to continue to have international data transfers, so transfers across border. They're already pre-approved and pre-agreed by both the EU Commission and also by the UK, and they are seen as an adequate level of control. This means that by implementing standard contractual clauses, the transfer of data will not have to end, and the transfer of data will still be bound by the regulation and by the guidance from the GDPR, meaning that you're going to be protecting the rights and freedoms of the individuals whose information you are using. It provides assurances to your the individual, the clients that you're working for, and it also provides assurances for your organisation as well. The important thing here is to remember that, of course, the UK will have its own UK GDPR, which is essentially the same as the EU GDPR with a couple of small tweaks. So we are going to be in a position to look after information in a manner in which people have become accustomed to, but implementing standard contractual clauses as soon as possible will just make sure that that consistent data flow can happen and protect your organisation from any problems further down the line. As always, this is a very, very brief overview of what can be a very complicated and complex topic. If you do have any questions or there's anything that you'd like to ask, you can find obviously our email address and contact details at the bottom of the page. There is more information on this on the Information Commissioner's website, which is also very clearly explained, and that's a fantastic place to go and look as well. For now, that's it from me, but if you do have any questions or you have any comments, please do add them below. And obviously, if you found this video useful, please do give us a like, give us a comment, give us a share, and don't forget to subscribe to the channel on YouTube if you'd like to know more or you'd like to see more of these videos. Thanks very much. Have a great week.